A very good morning, everyone. Chandrachud sir, am I audible?
Yeah. Yes.
Okay, Janta sir. Thank you so much. We're sincerely sorry for a bit of delay. So we'll just get started with this one. This e-workshop on intellectual property rights is actually organized by, initiated by IQAC Bidhan Chandra College. And our intentions from Bidhan Chandra College, Asansol, is to actually promote research and enterprise to like develop, and this program is developed especially for colleges and university students and faculties and university spin-offs, research centers, similar organizations. So as you know that intellectual property rights plays a vital role in today's economy, and definitely we all have to do our part, and it's going to be the new driver for the socioeconomic prosperity of the country in this area of globalization. So we're trying to create a large public awareness about the IPR issues like patent, copyright, trademark, etc. And this one is a step forward towards understanding and realization of IPR. This program will consist of two keynote speakers, like talks by two very eminent speakers on IPR field, and there'll be interactive sessions in the middle. And I'd like to personally thank the organizing committee, Professor Falguni Mukhopadhyay, our Honorable Principal, Bidhan Chandra College, and the chair, Gautam Mukherjee, and the convener, Chandrachud sir also, and of course the whole Bidhan Chandra college fraternity. And if you see that we had quite some response for this one, which is like 212 responses, a lot of it is actually faculties, which I understand like they're more interested into actually publishing and patenting their research works. And so the program as it goes, it will be started by the inaugural speech by our principal sir. Then the plenary session one is by Professor Jayanto Kumar Saha, who is a professor of law in Bankura University. I'll give the detail about his profile after some time. And then we'll have a short interactive session. Then we'll switch to the plenary session 2 by Dr. Sashinath Mandal. And then after the interactive session, we'll have a brief vote of thanks by our Prime Minister. And I'll just start playing with our principal sir's recording.
Good morning, everybody. At first, I very much congratulate to my Teachers Council Secretary, Dr. Chandrachud Das, and Professor Amit Banerjee, Department of Physics. Our college introduced new workshop on intellectual property rights. These important issues is a deep concern in our state, society, and institution. Naturally, our younger colleagues, students, and the registered participant must be benefited by this workshop. On behalf of my governing body, I congratulate all of the men of this seminar. Next, I very much grateful to Professor Jayanto Kumar Saha, Professor of Law, Bankura University, for his kind presence, valuable discussion for this workshop. And next week, Professor Sashinath Mandal, Hooghly Mohsin College, is related to this workshop. I very much grateful to Professor Mandal sincerely. Thank you all. I firmly believe that this workshop must be success in each and every sphere of our learning concern. Thank you all.
Thank you so much, sir. This was really encouraging. And so I'll switch to our the profiles of our speakers. which is to start with Professor Jayanto Saha. And I've been fortunate enough to be very closely related to Sir for the last few years' time. And we also wrote a book like 1 year back together. And so Sir's topic now is the intellectual property rights in an Indian perspective. And I'll give a brief introduction to Sir. He's born in 1962 in Kolkata in a middle class family, and he had early education in district town of Bardhaman in West Bengal. He received LLM and PhD degrees from University of Bardhaman. With more than 20 years of teaching experience, he has served as the Dean of Faculty and Acting Vice Chancellor of Bankura University, West Bengal. He has handled 3 international research projects with University of New South Wales, Sydney, Australia, AMRF, Dhaka, Bangladesh, and Swansea University, Wales, UK. And further, has also completed many projects under UJC and ICSSR New Delhi. He has guided 8 PhD candidates for PhD successfully. He has specialization in and has taught constitutional law, administrative law, and corporate law. He is a member of the Executive Council and the Court of Bankura University. He has been an Australian Indian Council Senior Fellow in 2011 and has involved in research activities in major Australian universities. He has been a visiting research fellow of the University of New South Wales, Sydney, Australia from 2010 to 2013. He was also awarded UGC India, so it's a UK-India Education and Research Initiative, thematic partnership 2016. As a co-researcher, he has published many research articles in different reputed journals. He has also presented paper in international conference, workshops in many universities abroad, like London University of Economics, Edinburgh, Nightmare University of Scotland, Swansea University, Wales, UK, University of Rovira I Virgilia at as a place in Spain. And so it's an honor to have you, sir, here. And I'll transfer the sharing rights to you, sir. Jayanto, sir.
Yeah.
Yeah, you can share or you can just continue, sir.
Okay. Good morning. Good morning, everyone. Thank you very much for kindly inviting me to this e-workshop, which is very significant initiative, especially in this very challenging time when we are separated from each other. And it's always a pleasure for me to address the dear students. It's a matter of great satisfaction and honor that Bidhan Chandra College, Asansol, is organized this e-workshop on intellectual property rights. I heartily congratulate the organizers and particularly Professor Falguni Mukhopadhyay, Principal of BC College, Professor Gautam Mukherjee, Dr. Chandrachud Das, and Dr. Amit Banerjee for taking initiative to organize this program in this virtual platform. I firmly believe huge advancement of students, teachers, and scholars in terms of application of technical knowledge and upbringing of the science. This type of webinar, e-workshop is a major milestone. I also feel extremely happy to be associated with my brother colleague, Dr. Shoshinath Mandal, who happens to be another speaker of this program. So let's start. It's not possible for me to share the screen due to some technical fault of my laptop. Instead of that, I'm using actually my smartphone. Please excuse for that. What I am going to talk about today, that is intellectual property rights, the Indian perspectives. Nowadays, it is very fast growing fields. I am supposing that most of the students are from science stream in the audience. And this is very fundamental that every student should know about intellectual property rights. In today's intellectual era, India has shown a considerable growth in its research and development. The presence of well-established state-of-the-art labs of Indian and as well as the multinational companies in the country has clearly proved the intellectual property status in the world. The rise in Indian economy is clear impact of intellectual property influence in the country. By setting up of new technology, incubation centers in various parts of the country, and providing financial aids to the technologists, the research and development status of the country definitely has been boosted up. Today, my lecture will cover the conceptual basis of intellectual property in Indian context. And then we'll also discuss about patent, copyright, trademark, and other related intellectual property rights. And these are the various kinds that will be taken briefly along with the case studies, their subject matter, their procedures, their enforcement part, the civil and criminal remedies, etc. latter. So first of all, the question is, what is intellectual property rights? Intellectual property is a creation of your mind, something which comes by the application of your mind, something that you create with the application of your thought, intellect activity, and offshoot of your intellect. There have been several things. It is only you create or you come out with the application of your mind, your judgment. I will try to put some examples in various kinds of intellectual property like patent, copyright, trademark, geographical indications, and designs. I'd like to share the basic ideas of these intellectual property rights. Copyright protects written or published works such as books, songs, films, web content, and some artistic works. And patents protects commercial inventions, for example, a new business product or process. Designs protects designs such as drawings or computer models. Trademarks protects signs, symbols, logos, words, or sound that distinguish your products and services from those of your competitors. Several creations are there which comes under the ambit of various kinds of intellectual property, such as writing. Whatever you write is literary matter. It is your copyright, and it is under intellectual property. Whatever you create in the form of art, in the form of paintings, in the form of music, or say make a cinematograph film, or a song written by a lyricist, or something made by a composer. So at that time, you can easily be given the intellectual property protection. But it's a matter of identifying what intellectual property can be granted or given to a person for that particular work. So first of all, you have to understand whatever work you create, artistic, literary, as far as copyright is concerned. We may give copyright, but we'll have to understand that this work has to be original. It has to fulfill other obligations of copyright protection. Another example to understand the definition of intellectual property, we have a lot of inventions taking place with the help of new technology, with the usage of internet, information communication technology. A lot of literature is flowing on the cyberspace. And we also get to see a lot of pictures posted by the people. We also see a lot of literatures written by the people. All inventions done by the scientists in the form of drugs, pharmaceuticals, or say other types of inventions to facilitate the people's lives comfortably. The question is, are all work creations of the mind? So these creations, if can be brought under the definition of the subject matter, these subject matters are defined separately. Different laws are there. If the intellectual property or the work created under any of the subject of the intellectual property that can be easily granted and given a copyright or a patent or a design on intellectual property protection. But for that, you will have to understand your work, your creations, your creativity is new, is a combination, and is a thing which falls under the definition of law. You can easily have a protection of any branches of intellectual property. I mean, intellectual property protection. We have other things also that can easily be an example of intellectual property. Computer programs, logos, designs, these are all copywriting. So there are several things which has a copyright, which can be given copyright protection. The performance of a person can be given protection. Suppose a juggler, he performs before the audience, or an actor performs before the audience. He can have a protection over his performance so that others cannot misappropriate it, cannot make false or wrong use. Person can have a protection of music, whatever music composition is created by a person. It's creativity. It requires skill. It requires judgment. It requires application of the mind. This is all within the ambit of intellectual property. Another example to be given for realization to understand the intellectual property in the easiest manner. We get to see a lot of things in a normal course of life. We go to the market. We want to purchase a pair of shoes. Why do we always look into the brand? What promise do they give? Why you choose a particular shop, you know? Suppose a sweet shop. We go to the Haldiram, Kesi Das, or Bikaner. It means you always give priority to the brand, his name, It means you prefer the manufacturer or brand due to their performance, and you choose under the edges of that manufacturer, and that assures you the quality, that assures you the best quality product. That's why you get attracted and buy the things in the marketplace. All these logos, names, brand are called trademarks. Several peoples owned by them. You cannot use the trademark without their authorization. If you use it unauthorizedly, that goes against you, and that is infringement. You may institute with the infringement action. Some other kinds of remedies also be obtained by the owner of the property through the court of law. Similarly, we have several trademark services. In the case of services, we see a lot of trademarks. These are called the service marks. Actually, this is the particular name, that this is trademark services mark. For example, hotel chains are there. Suppose Oyo. Oyo actually is a very popular hotel chain. If you go through the restaurant chains, you see in Calcutta, the O Calcutta restaurant. This is also very popular. Actually, they are rendering services in hospitality services. Food they provide in their restaurants are all the examples of trademark. And if you coming to the design, example of a design for the intellectual property, one can easily see when one buys the product, he or she always buy the product which attracts, which appeals to his eye. It is your requirement, otherwise you cannot buy anything. Under the designs, several things are protectable. The shape, the configuration, sometimes it can be 2 or 3 dimensional. So it can be given design protection. Once you obtain the protection, it remains for the stipulated term. Within the stipulated term, the owner has enjoyed the protection of intellectual property. So if I like to discuss about the nature of intellectual property rights, then I must say that intellectual property rights are the territorial rights, which have a fixed term and can be renewed after a stipulated time. Exceptionally, trade secrets have an infinite life and they don't have to be renewed. Apart from these, trade secrets have another nature of being assigned, gifted, sold, and licensed, like any other tangible property. Unlike other movable and immovable properties, these rights can be separately held in many countries at the same time. Intellectual property rights can be held only by legal entities, that is, who have the right to sell and purchase property in the other way. Any non-autonomous institution does not have rights on intellectual property. These rights are protected by their respective sections and rules. So I hope you understand what is meant by intellectual property rights. In a nutshell, I once again repeat, intellectual property are the creations of the mind of the people. Something processes work, processes product, literary work, artistic work, cinematographic films, paintings, drawings, sculptures, designs. And these are the various examples of intellectual property. But the requirement is that they should be offshoot of your mind, must not be stolen thing, which is somebody else's property, must not be stolen product. It is undoubtedly the real owner's property. So now I will discuss about the definitions of intellectual property, which are given by different legal philosophers. The normal definition is intellectual property rights are generic terms of exclusive rights given to the results gained by humans' original intellectual activities. They signify the intangible See, when you get the intellectual property rights, you get an exclusive right of your creativity. You just see another definition of World Intellectual Property Organization, that is WIPO. Intellectual property shall include the rights relating to literary, artistic, and scientific works, inventions in all fields of human endeavor, scientific discoveries, industrial designs, trademarks, service marks, and commercial names and designations, protection against unfair competition, and all other rights resulting from intellectual activity in the industrial, scientific, literary, or artistic fields. If you see these definitions, a lot of things are basically under the purview of this definition. Literary works, scientific works, product processes, designations, designs, etc. This definition is exclusive. It's not an exhaustive definition. Many things which easily can be brought under this definition. New things can emerge. New manifestations can emerge tomorrow and can easily be brought under this definition. So now I want to discuss about TRIPS. What is TRIPS? It is the agreement on trade-related aspects of intellectual property rights. TRIPS is an international legal agreement between all the member nations of the World Trade Organization, WTO. It specifies enforcement procedures, remedies, and dispute resolution procedures. We have a good enforcement procedure of the intellectual property infringement, not only in India, rather many nations which are signatory members of TRIPS. In the definition of TRIPS, the term intellectual property refers to all categories of intellectual property rights, which are subject of a specific provision of TRIPS agreement, that copyright, trademarks, geographical indications, industrial designs, patents, layout designs of integrated circuits, and protection of undisclosed information as stipulated under the TRIPS agreement. So these 7 kinds under the TRIPS are almost recognized by all the member nations. They all have complied it and having their domestic legislations. They have the domestic legislations earlier, but with the inception of TRIPS, they have to make certain changes. Some nations are still in the process of doing it. But these 7 kinds of intellectual property are recognized by the TRIPS and equally recognized by the member nations. But one thing, everybody has a question that why the intellectual properties are required. What is the need to introduce intellectual property rights? What is the need of having it? Intellectual property is required the way you require the other properties. You own a house. you own a car. You own several other properties. Those properties you own a normal way of life are tangible properties, which can easily be perceived and seen in the eye of a person. But intellectual property, unlike normal properties, is what? It is intangible. That cannot be perceived by sensation. It cannot be seen, but one can easily own it, which is why we require it to have an intellectual property rights. If we are denied of these rights, then the misappropriation of the same property will take place, and that may lead to the chaos in the society. So for the better order in the society, we need a right over the intangible assets, and this is the reason as to why we have intellectual property rights. I also like to discuss about another vital point. Is intellectual property a balance between the public rights on the one hand and the private rights on the other hand? When the person is avoided intellectual property, say patent protection, he or she get it for the stipulated term. The terms stipulated by the Patents Act 1970 are 20 years after obtaining the patent. So these 20 years, the persons enjoy the rights of the patent by using it, utilizing it, and earn money from it because it is his private right. It's his personal right to do that. In our Indian Constitution, we have a provision to have a property. It is not a fundamental right, but it is a constitutional right. Similarly, you see in the case of intangible assets, one can easily earn it, one can easily use it. Patent is a limited right, limited in terms of time, limited in terms of space. So it remains with the person for the stipulated term. Because after 20 years, it falls under the public domain and the public may use it. So in a way, you can say that public right and private rights are being balanced. So another point is economic significance. Nowadays, our ages of information is of knowledge, and economy is based on the knowledge. It is based on new inventions, and it has been constant endeavor of the human being to make the life comfortable, smooth, by bringing into new mechanisms. You know, economic significance, if one entity, one organization, if owning a intellectual property, always have an additional advantage over other organizations. I mean the organizations who does not have any intellectual property. These intellectual property are very lucrative, especially patent is very lucrative. It has got a lot of money, plenty of money because of the owning of the intellectual property. Its economic significance is not debatable at all, not disputable at all. It has got a lot of potential and it can be exploited in several mechanisms. I mean by using several mechanisms. Another reason to have the intellectual property that it serves varieties of industry. It serves information industry by production and distribution of books, magazines. It serves entertainment industries. It serves television and broadcasting. It serves manufacturing industries. And it also serves pharmaceutical sectors. So there are several things which easily can be brought under this ambit. Many organizations can be framed of the similar sort of listing using, having, possessing, owning intellectual property. So that is the need, the necessity of intellectual property concern. Next question comes in our mind, that why intellectual property matters. Why do you want to own a property? Suppose when you own a small land holding, it's your property. You own it and you feel good. You have something at your disposal. You own other things, other properties like car, gold, jewelry, lot of things you own. But these are tangible assets. When you own intangible assets in the form of intellectual property, they are equally important. I already mentioned that intellectual property is very lucrative one. It gives you a lot of money, lot of fame. That's why intellectual property matters. Now let us see what is patent. Just a minute. What is patent? Earlier, when intellectual property right was in its preliminary stage, a lot of problems arose relating to its implementation, policies, act, rules, financial and governmental support. Earlier, companies and inventors were also not aware about intellectual property rights. Therefore, risk of infringement was at an alarming level. Without a healthy system, companies were not interested to go for research and development process in India. This resulted in the death of inventions, high risk of infringement, economic loss, and decline of an intellectual era in the country. Keeping in view all the problems, India has taken strong steps in strengthening IPR in the country. New patent law was made after independence in the form of the Indian Patent Act 1970. Later, it was amended in compliance with the TRIPS provision. And very recently, in 2005, amendments were made in intellectual property rights, patent and other acts. So when we talk about three important things are to be noted. First thing is that patent is an intellectual property given for inventions. Second thing which is to be noted is that patent is for a particular period of time. Granting of patent is for 20 years, I already said. After the protected period, patent becomes the off patent. Off patent means anybody can use the patent product after the period of 20 years. After this period, patent is open to use by the general public. The third thing, which is to be noted, that according to the TRIPS agreement, every member country has to shift from process patent to product patent. From process patent to product patent, first let us discuss what the history of patent law in India is. The first patent law was passed in 1911, and it was passed by the British government. Their aim was to maximize the profit of the British companies. By this process, British companies charge higher prices for their products. These higher prices help them to maximize the profit. At that time, it was product patent, not a process patent. In the year 1970, the Indian Patent Act was passed. Under this law, the government allowed the process patent along with product patent. This was allowed especially in the area of food and pharmaceutical sectors. This has allowed the pharmaceutical companies to produce the drugs at a cheaper price. We have seen a tremendous improvement of the production of drugs and what I'm saying that, okay. So in 1970, the present Patent Act was passed. Under this law, the government allowed the process patent along with the product patent. And this was allowed especially in the area of pharmaceutical sectors. And what the pharmaceutical companies to produce the drugs at a very cheaper price. We have seen a tremendous improvement of the production of drugs, especially the generic drugs in our country. The patent is for 20 years. So from the year 1970, it means for the next 20 years, and after 20 years, it becomes off patent. So after 20 years, anybody can produce that drug, anybody can produce generic drugs. So generic drugs, this composition will be the same. So everybody can produce the same product in a different name. This is how the India captured the world market of pharmaceuticals. After that, India has become the largest producer of pharmaceutical drugs in the world. This is the introduction of process patent. Now we are able to actually export the drugs even in the United States because it is cheaper and quality is also good. So it increases the drugs production in India. So we can say that introduction of process patent was a recent growth of pharmaceutical industry in the country. In 1995, India joined the WTO, World Trade Organization. The question is, what the impact of IPR for joining WTO? Under the WTO, the member countries had to comply with the TRIPS agreement. And in this agreement, every country had to shift from process patent to product patent. But for different member countries, different time frame was given. And in order to comply with this particular agreement, the developed countries were allotted a time period of 1 year, and the developing countries like India, the time frame was 5 years. So within 5 years, they have to comply with this agreement. So within this stipulated time, India had to adopt product patenting. We are compelled to move product patenting. In order to comply with this, the government had to ensure the interest of various stakeholders. Drug price control order was passed. Prices of essential drugs will not come under any contract or law. By complying of the TRIPS agreement, the most important thing the government had in mind was to control the prices. So the government could not offer and increase the prices of the drugs in order to keep the prices of the drug under control. They introduced Section 3D of the Patents Act 1970. It is very, very important. Let us see what Section 3D of the Patents Law is. The aim of any pharmaceutical company or any multinational company would be to maximize the profits. After 20 years, patents become off patent. So after 20 years, when patent becomes off patent, at that time, what the pharmaceutical companies do, they will appoint a research team. And the research team will come up with a conclusion that the efficiency of the drugs has come down in these 20 years. So they will come up with a new drugs. And with this new drug, they will apply for new patent. And if the patent office grants the patent, they can use this drug for another 20 years. So another 20 years, they will have a monopoly. And if the new drugs are slightly different from the old drugs, another 20 years, they will enjoy the monopoly. And this resulted evergreening of patent. You must understand what is evergreening of patent. Section 3D of the Patent Act was introduced to prevent this evergreening of patent. It says that there should be an enhanced efficiency required in order to get patent for an already existing drug. But it is not clear that what is the criteria of an enhanced efficiency. There is no proper definition given by the patent office. I want to cite a remarkable case of Novartis case. It is a multinational company dealing with pharmaceuticals. They updated the patent of a particular drug, Gleevec, G-L-E-V-S-C, Gleevec. The patent office rejected the application, saying there is no enhanced efficiency in the drug. The company approached the Supreme Court of India, and a landmark judgment was passed by the Supreme Court. It said that enhanced efficiency means there must be therapeutic efficiency. The Supreme Court also said that minor improvement cannot be considered as therapeutic efficiency. And therefore, the Supreme Court rejected the application of Novartis company, saying that there is no enhanced efficiency in the drug Gleevec. With this judgment, the drug Gleevec has no patent in India. But the United States is not in favor of Section 3D of the Patent Act of India. Why the United States against it? Because of the multinational pharmaceutical companies in India are from the United States and mostly the European countries. So it is very difficult for them to get patent for the existing drugs in India. And this has lowered the profits and business interest. United States says that India is very poor about intellectual property rights law. And India does not follow the TRIPS agreement. This has led to many debates, but in the Indian context, 3D is a very, very important because it prevents the evergreening of patents. The advantages of 3D are that drugs become affordable and there is no competition, and the surplus of the production can also be exported to other countries. India also produces drugs at a low cost for other developing countries like Africa. So now I'd like to discuss the method of intellectual property rights registration. how you register it. Actually, intellectual property can be either registered or unregistered. With unregistered intellectual property, you automatically have legal rights over your creation. Suppose you write a PhD thesis paper. You never registered it, but you automatically have legal rights over that. Nobody uses your PhD thesis paper without your permission. Unregistered forms of intellectual property include copyright, unregistered design rights, trademarks, database rights, confidential information, and also trade secrets. With registered intellectual property, you will have to apply to an authority to have your rights recognized. If you do not do this, others are free to exploit your creations. Registered forms of intellectual property include patent, registered trademarks, and registered design rights. And copyright is also in part registerable. And so far as copyright is, India is a signatory to the Berne Convention on Copyright. In most cases, though registration is not necessary to maintain a copyright infringement claim in India, but registration is made in person or via a representative with the Copyright Office. And since 2016, copyright policy was moved to India's Ministry of Commerce and Industry. All IPRs are now administered by the Department for Industrial Property and Promotion, which is called DIPP. So the rights of the authors of literary and artistic works, such as books and other writings, musical compositions, paintings, sculptures, computer programs, films, these are all protected by copyright for a minimum period of 50 years after the death of the author. After the death of the author, this particular rights enjoyed up to the period of 50 years. And so far as patent is concerned, India's Patent Act of 1970, 2003 patent rules, and 2016 patent amendment rules set out the law concerning patents. The regulatory authority for patents is the Patent Register under the Office of the Comptroller General of Patents, Designs and Trademarks, which is part of India's Ministry of Commerce and Industry. And patents are valid for 20 years, I've already said, from the date of filing an application, subject to an annual renewal fee. India's patent law operates under a particular principle, first to file. Whoever first filing, he is the owner of that particular patent. That is, two people apply for a patent on an identical invention. The first one to file the application will be awarded the patent. And also in case of designs, the laws governing designs are the Designs Act 2000 and the Design Rules 2001. Designs are valid for a maximum of 10 years, renewable for further 5 years. And so far as trademarks is concerned, India's trademark laws consist of the 1999 Trademarks Act and the Trademarks Rules of 2002 and 2017. The regulatory authority for trademark is the Comptroller General of Patents, Designs and Trademarks under the Department of Industrial Policy and Promotion. The particular policy, actually this policy now have more robust powers in enforcing trademark law, including the ability to search premises and seize goods suspected without a warrant. It is advisable for right owners to register their domain names in India as trademarks as soon as possible. Registration actually takes up for 2 years, up to 2 years. A trademark in India is valid for 10 years and can be renewed thereafter indefinitely for further 10-year periods. So this is all about the registration procedure. And now I also want to discuss in short about enforcing intellectual property rights in India, enforcing part. So intellectual property rights can be enforced by bringing actions to the civil courts or through criminal prosecution. India's intellectual property laws set out procedures for both civil and criminal proceedings. Criminal proceedings do not apply to patent and design infringements. A disadvantage of civil litigation is that you are unlikely to recover legal damages. However, if you have an identified infringer, it may be advisable to file civil litigation, because if an interim injunction is granted, the infringement can be halted, pending the outcome of the case. So damages are routinely awarded in cases of copyright, piracy, and trademark infringement, which come under criminal litigation. So over the years, decisions in favor of foreign companies against local infringers have demonstrated the judiciary's impartial approach. So lastly, to conclude my lecture, I must say that today possession of land, labor, and capital are just not enough for a country to succeed. Creativity and innovation are the new drivers of the world economy. The policies adopted by a country shall determine the nation's well-being. Development of a country's intellectual capital is the most An effective intellectual property rights system lies at the core of the country's development strategies. Although India has complied with all obligations of TRIPS agreement by amending the IP laws, certain issues are still needed to be taken care of. And there is need for a constant thinking over the core issues of IP protection in order to respond to situations arising out of global competition. So I may stop here. At last, again, I would like to convey my thanks to everyone for patience hearing. Thank you.
Thank you, Dr. Saha, for your wonderful and inspiring speech. I am talking from the desk of the convener. I am Dr. Chandrachud Das. I express my most deepest gratitude to you, Professor Saha. Now we have a very large number of questions in the chat box. We have already overshoot our time, so I would request you to answer them in very short, sir. First of all, I have a question from Lakshmi Narayan Mahato. He has asked a very beautiful question. What is the scope and career opportunities in the field of IPR?
Actually, in India, till now, there is not a big shot of IP expert in our legal field or also in other fields, but there are enough opportunity to do so. So if you want to build your career in intellectual property, then there are so many courses in various fields, including our legal fields. So you have to join there, and there are enough scope because in future, this particular field develops rapidly. And with this, and there is other one particular field, which is the cyber space. It means the cyber law and cyber related fields. This is also very, very prospect fields. I think so.
Well, yeah, actually, Lakshmi Narayan Mahato has asked quite a lot number of questions, many of which are very interesting, sir.
Yeah, yeah.
Another question from him: can the indiscriminate use of one's own content be a violation of IPR? He's using his own content, then can it be a
Ha, ha.
violation of IPR?
No, actually, this is one of the very, very relevant question relating to intellectual property rights. If I publish a particular article, and if subsequently, if I publish that article not in a reprint manner or reuse manner, but if I use it as a new article, then it, of course, it is also comes under the type of the process patent. It means that you use it in a particular, just doing something changes to, which is very minor changes. So it can't be. You can't, you have no right to produce it further subsequently in a same manner. But wherever you cite it, you use your particular content in a subsequent your paper or like that, then you must acknowledge that part. I think our next speaker, Shoshi, also highlighted this point.
Okay, sir, another question from one of our colleague, Dr. Amrita Banerjee from the Department of Pol Science. She has asked, how will the COVID-19 pandemic affect on intellectual property? And this question has been also iterated by many others. This has not only by Amrita, this question has been repeated by Shubhra Bokul and also by Sunita Mandal, and many others have asked this question. So please,
Actually, COVID-19, really it affects in every aspects of our life, no doubt about it. So, so far as intellectual property rights is concerned, definitely the official, the management system, the official system are not closed totally. So if you feel that your rights has been infringed by someone or by any way, then you definitely file a complaint, file a case also, go for the criminal proceedings or the civil proceedings, whatever the law permits. You can, but the thing is that overall COVID-19 definitely affects in all aspects of our life, including our rights.
Okay, another question from Lakshmi Narayan Mahato. That's a very interesting question, sir. The question is, what protection IPR provides against plagiarism?
I'm not interested to answer it because this is the purely the purview of our Shoshinath Mondal's speech. So definitely it covers from that. Yeah.
Okay, sir. Okay, sir. Thank you, sir. I don't think we have any other questions in our chat box. So once again, I thank you most heartily for your speech. I will now transfer the microphone to Amit Banerjee for our next speaker, Dr. Shashinath Mondal. Thank you, sir. Once again.
Thank you. Thank you.
Thank you so much, sir. Thank you so much, Jayanta sir. I mean, this has been a very, very interesting and I'd say very like detailed technical discussion. I mean, we're very thankful for you to come in here and actually share your views on this one. We'll definitely have more questions and probably people can directly write to you or call you sometimes when they feel like. Yeah, that'd be really, really great if you like answer them in later sometime. Some of our students may be interested in this one. So thank you, sir, again. And I'll switch over to our next speaker and is more detailed into the academic part of this thing, which is the intellectual property right creation and protection for academicians under Indian patent law by Dr. Sasinath Mandal, WBES, Assistant Professor of Law, Government Center for Legal Education, Hubli Mohsin College, Government of West Bengal, Chuchura, West Bengal. So I'll just give a brief introduction for our speaker, who is a LLB, MSW, LLM, and a PhD. And sir is a assistant professor of law, also serves as a deputy director of the Public Instructions West Bengal in 2015, as nodal officer HCCMC Higher Education Department, Government of West Bengal in 2016 under the West Bengal Education Services. After his schooling from Bardhaman NVM High School in 1992, graduated from Bardhaman Raj College in 1996 and LLM in 1999 from University of Bardhaman. Author had the honor of becoming the member of Bardhaman Bar Association and has practiced for a couple of years as advocate in District Judges Court Bardhaman. After his LLM in 2004, his specialization of business law from the University of Bardhaman, he has forthwith joined the Law College Durgapur as lecturer in law and shouldered the responsibility of the founder in charge of the Law College of Durgapur Rajband Bardhaman. He has qualified UGC NET with JRF and joined his doctoral research work in the Department of Law, University of Bardhaman. He has been awarded the PhD in law in 2010, the field of intellectual property rights. His subjects of interest are I can't pronounce that, intellectual property laws, administrative and constitutional law, cyber law, human rights law. He has published more than 50 articles in international national peer-reviewed journals of high repute, which are published from India, United States, Germany, etc. He has attended and chaired many national and international seminars, workshops, etc. in India and abroad. He's a regular trainer in WB Administrative Training, Police Training, Judicial Training Academy, many other centers for the training throughout the nation. His book on copyright laws, cases and materials is published in 2011. Another book, Understanding and Copyright Through Judicial Precedent. A glimpse of the copyright development was in 2012. His edited volume in Empowerment of Women, Human Rights Perspective was published in 2016. Corporate Governance, Emerging Concerns was in 2017. He is an executive editor of Global Journal for Judicial Sciences, a peer-reviewed half-yearly interdisciplinary journal. He's a recognized PhD research guide of the University of Bardhaman, West Bengal Specific University, and Udaipur PhD research guidance of the and Rajasthan. He has been guiding scholars for doctoral research work. 4 scholars have been awarded PhD in law under his supervision. He's a member of the many research journals in India and abroad. The speaker is a life member of Indian Institute of Public Administration in New Delhi. Quite a lot, sir. I have transferred the sharing rights to you. So if you have a file to share, you can just continue this one. Sasinath, sir. Hello. Sasinath, sir, you are not audible. Hello.
Yeah.
Yes. Yeah, we can see you, sir.
Okay. Just I'm taking 2 minutes, okay?
Yes, please.
The authority who has given me the opportunity to speak on the subject, which is one of my favorite. Today, I'm very happy to be the part of this wonderful workshop on intellectual property rights. Before I will start, I would like to extend my obligation, gratitude to Professor Falguni Mukhopadhyay, the principal of the college and the patron of this workshop, and the chair of today's workshop, Professor Gautam Mukherjee, the convener of NAC committee and HOD of the physics department. I'm really grateful to the convener, Dr. Chandrachud Das, who has extended me this opportunity, and the IQC HOD Department of Chemistry. I also extend my thanks to the joint convener and the person who has contacted and who has given me all the information about this, Dr. Amit Banerjee, Department of Physics. Last but not the least, I am thankful to my senior Dada, Professor Jayant Kumar Saha, who has given me the opportunity to be the part of this workshop. Today's workshop, as I have chosen it, considering the importance of the subject and the role of this subject in academic. We know that the intellectual property, as my elder brother, Professor Saha, has elaborately discussed about intellectual property. I'm not going to that part, but I will focus on intellectual property creation. We know that this teaching and academic fraternity is working only by the use of their intellect. Therefore, the subject intellectual property is very much relevant in the field of this academia and research. I will focus on intellectual property part only, which are relevant, which are very much essential for the intellectual use of academicians. My first, I would like to focus on this intellectual property. If we take the very existence of this intellectual property, we will get that before this new laws, new arranged laws, codifications, legislation process, which brought a lot of laws. And these laws are, as we know, has come only on the basis of the need of the society. But before that, if we think about the development of the law, then you'll get the one idea that became essential, that gave birth to all these laws, was the economic addition to this intellectual development, intellectual use. Before the Berne Convention, we have only one idea, we have only one history. In UK, where the focus was given on this use of intellectual creation, creativity, not in the terms of intellectual property right, but only in terms of the value addition to the time, to the money invested by the people to create anything by the use of their intellect. So the Statute of N in 1709 and 10 was the first incident, was the first initiative which gave birth to this idea that anything used, anything invented by the use of intellectual should be paid up, should be valued. And taking the reference of that only, in 1886, we got a very remarkable conventions where for the first time it was thought that the property which had some value in the society and created by the use of human intellect should be kept aside, and a economic addition, a value addition should be added to the creativity by the use of intellect. And after that Berne Convention, we got the idea of one property. It's called industrial property. It's called industrial property. The industrial property was the soul of all intellectual property. Therefore, it can be presumed in this 21st century also, the intellectual property has a very important relation with the industrial use. If someone like us applies their mind and developed one thing, but having no use, then it has no value in today's world. So literally, it was industrial property which gave importance to this intellectual property. Therefore, I have divided this today's intellectual property into two. One is the copyright and related rights, and the industrial property. So copyright and related properties and industrial property still, because copyright is the right which is vested to the person who has applied their mind, who has invested their money to get something evolved, to get something created by the use of one's intellect. It may sometime, it may have industrial use or may not. That's why I have divided this into two sector only. So first, I'd like to focus on copyright because it is the most important part which the academician focus on. So copyright, as already discussed by my senior Dada, Professor Jayant Kumar Saha, just I am focusing the areas where we can get the copyright. Copyright includes literary works. Works is very much relevant for the academicians. We are focusing on literary works. We are actually developing ourselves through the use of literary works. Second is the dramatic works. I have used the term films here. Dramatic works. Dramatic means the creation which is performed in the form of drama. Third was the musical work. Musical work. that is the music. And fourth is the artistic work. Any person who, by the use of letter, words, lithography, whatever, in any form, if he has applied his artistic idea, then that will be artistic work. And that is protected under copyright. Another is the cinematograph. There is a law, Cinematographic Act, and that law provides protection to all films. We know that all films has to get the clearance of censor board, and that is provided under that law. So that is also protected under the purview of copyright. And another term is the sound recording. That sound recording is another very interesting part of musical work, because musical work is there and sound recording is there, two different things. So the right involved in sound recording is vested to the producers, and the musical work is vested to the lyricist or other person who applied his mind. Another part is the industrial property. Industrial property, other four important intellectual properties. I have included these like patents, trademarks, industrial design, geographical indications, farmers' right. Other things are there, but these four are the important intellectual property which has use in industry. That's why it is industrial property. We are focusing on IP creation. As in the last, we have discussed in the last slide about the copyright and other industrial rights. So basically, academicians are creating their right in these two segments. If someone is writing an article, books, research articles, reviews, everything, they create by the use of their intellect. Therefore, this creation is protected under copyright and other related right. Related right means there are a lot of rights is mentioned here. These all are called related rights. Literary works also includes here the computer program. In India, this is very unique thing in India that we have got this computer program protected under copyright. If you compare this from US, there they have got it in patent only, but we have got it in copyright. We considered it as the intellectually used in literary work, not in industrial application or use. Therefore, in India, the protection has been given only in copyright and related right. Thereafter, here the performer's right. Here is the right to adaptation right. Right of translation. One can translate the right. One can translate any work, and that right created through translation will also get the protection under the copyright. One can write one play or drama that can be performed, and they will get a separate right called performance right. So in this way, copyright is one segment, and other rights related to copyright are also protected within the ambit of copyright. Why the copyright need to be protected? We know that we, the academicians, are basically focused on creative writing in the form of articles, in the form of books, in the form of any reviews. But why it has to be protected? Because the copyright is the right given to the owner or creator owner or author. And that right is given as because the person has used his or her intellect to develop that particular idea. Therefore, the copyright is the protection to the expression only, not to the. Hello? Hello? Hello?
Hello, we can hear you, sir.
Yeah.
Continue.
Okay, okay. Yeah. So suppose someone has developed anything by the use of his intellect, but until that use of intellect should be rewarded, should be appreciated in the form of economic addition. That is the purpose. So the interest and the development both will endure. Therefore, this right of copyright, right of copy has been developed on the basis of the a very focused concept of value addition to the to one's idea of creative work. So the rights of the author over the creation they are protecting. Another important reason is that the creation is required for the development, but that development also connected to the involvement of money and wealth. And until that money and wealth will be supported for the creative work, the creative work will not continue forever. And the third one is that if someone will get the value of their intellectual use, intellectual labor, they will work at as a motivation for the further work. And other important thing is that in society, until there should be restrictions to use other work in any way, the proper development may hamper. Therefore, the copyright is very important in this society. Now, what are the rights what a copyright owner, a creator of copyright can get? So the copyright owner can get multiple rights. So besides the right to produce, to develop, to publish, they have multiple rights. They can publish their work, they can perform on their work, they can translate their work, they can make films or any presentation on their work, they can broadcast their work. These are adaptation, they can sell the copy of the works. So these are the rights which are related, which are mentioned in the copyright law as the right of the copyright owner. Now, what is the value? As we know that copyright is an exclusive right is vested to the owner or the author. Then what is the value of this exclusive right until it gets the right to transfer? Therefore, copyright can also be transferred. And this assignment of copyright may be in two forms. One, in the form of transfer, since it is a property. It is a property which is not seen. It is an intangible property which has a monetary value. Therefore, it can be sold out, it can be leased out, anything in the mode of transfer which we have. The same way as we are using our other tangible property. But in place of transfer, we can give it on license also. And in our law, there are two kind of licenses basically given, and one is the privileges, that is also called statutory license. Two licenses are there. One is voluntary license, other is compulsory license. Voluntary license is the option of the author or owner is to give someone the right to use their work. Any person having the right can give his or her right to any person on contract, for temporary period, for permanent period, for voluntary, depending on the ideas, depending on the profit, depending on the development of the particular concept, considering the profit he want to earn, he can give the voluntary license of his work. And compulsory license is very important term, which is incorporated in the copyright. Compulsory license is used by the government to extend on these conditions only. We have experience that in some official libraries also, you may get some xerox or copied books. Is this a violation of copyright? To get the copy of original book xerox and to keep it in the library? Generally, yes, it is not allowed. It is not allowed. But it may be permitted. And these circumstances are when the person who has developed his work, the person who has created his work, has withheld the work from the society. That means the work is known to people, but is not available for the public. Therefore, the government, through Copyright Board, can extend license to the person to use by getting it copied, getting it xeroxed, whatever. And another is the unpublished or published work. That means if some work is written or created by someone, but the person is not available, the person is not found or is not living, but work is important. Therefore, any interested person can publish the work taking license from the Copyright Board. And Copyright Board, upon the request written prayer from the interested person, can allow anyone, can grant compulsory license of publication of any work which is either unpublished or published, but it is not reprinted, it is not revised, whatever may be, but it is important for the public, it can be done. And third one is for the benefit of disabled person. If any person working, creating any documents for disabled persons, working or disabled, which is not available, or the work belong to a person who is not interested to give on any terms, thereafter only the Copyright Board can grant compulsory license to the applicant if they're working for the benefit of disabled person and the work will benefit the disabled person. Then, and statutory license, one condition that is applicable, and that condition is statutory condition. We may experience this when we watching any movie that certain conditions is warning is given, voluntary disclosure is given, and that voluntary license is granted to any person. And this license is granted many a time. This license is granted to these radio stations, these network stations, these nowadays the internet stations also, when of others. Am I audible?
You're audible, sir. Please continue.
Hello?
Hello. So you're audible.
Okay, okay. Yeah, yeah. Thank you. So, in that conditions only, statutory license is required. So suppose someone is running a radio station, FM like that, then they need to run a lot of music. They need to run a lot of clippings. Therefore, these kind of licenses are required to use some copyrighted works of other person. Now, how? These are the rights which is created, which can be owned by any academicians through their creative works. Now, how these can work as infringement? What is infringement? First, infringement is a very specific term used to define that someone has used the works of others without taking permission of the person. Whose work? So the person who owned the copyright, or the person who has created, the creator or the owner of the copyright, has the right to use his copyrighted work exclusively, has the right to sell, to transfer, to use, to exploit the work commercially. Is very important to define whether there is infringement or not. Very interesting formula. If someone get one printout of a work from internet, can it be infringement of copyright or not? So that can be tested by the use of commercial exploitation. So if the person has copied that particular page for the use of studies, for the use of development, for the use of research, so that cannot be treated as infringement. But if that is copied to get some monetary benefit, to get it transferred to some person for some cost, then that is absolutely infringement of someone's work. So that infringement of copyright is an act through which any person copying, transferring anyone's creative works. It may be in terms of artistic work, in terms of literary works, in terms of music, in terms of video, whatever. These all are termed as infringement of copyright if someone copying it, using it without permission and to make profit. Commercial exploitation is very important for the purpose. Now, we know that we the academicians, basically, we are working, but most of the academicians are not aware as to the form when there can be infringement of copyright. Not aware. Why? Because of the particular acts, whether a particular act infringes the copyright or not. That is very important. So therefore, just we try to understand what are the acts which can termed as copyright violation or infringement of copyright. So copies of copyrighted work are made for sale, hire, without permission or authority, like in the case of online piracy. So if we are taking anyone's copy, if you are taking copy of anyone's works without any permission, including in the online, that is absolute the act of copyright violation. If we perform a play, if we developed a play on the basis of any writing of any person without taking permission, that is also copyright violation. Here, it may happen that we have translated the work without any profit. That is also copyright violation, because we are changing the very nature of one's work. Someone has created the work only in the form of play, not in the form of drama. And if someone taking it and playing it on stage, that is absolute violation of copyright, because it is not permitted. And if someone get the copyrighted copies and distributed among the students or researchers, that is also copyright violation. So academicians should always remain conscious about getting one work's xerox, getting one work's copy, and to advise the student to get it copied, because these all are the classic examples of copyright violations. We do not supposed to copy anyone's creation without one's permission or authority. But there are certain acts which are not copyright infringing. It is very important to understand when we are not infringing and when we are infringing. So these are the acts under which we cannot term as infringer of copyright. The very term, as per Indian perspective, is a fair use, whereas suppose in US perspective, there is a fair dealing. The fair use is a term we in India we use, and this is a very important defense when we are getting someone's creative works, when we are copying someone's creation, whether it is infringement of copyright or not. So we can take the defense of fair use, that we have not used this particular work, particular copy for any commercial purposes. That is a very important fair use. That means what is fair use? Now you have used the word, a particular work, fairly in terms of development, education, research, and greater public interest. If someone, if a particular judge has written one judgment, and that judgment has included any reference of any person's writing, can it be considered as violation of copyright? No, it is exempted, since the original concept was not to develop any creative work, but to refer the work to conclude on other decisions, other conclusion in any other matter. Therefore, the reference, giving a reference to the particular work will not create any infringement. We know that public dances, public performance at any place without taking permissions, without taking also considered as violation of copyright. Now, last one is the making sound recording of literary, dramatic, musical works under certain conditions. So we cannot copy anyone's dance, song, literary work, musical work under some under general conditions. General conditions means we are taking a song and singing a song to get some money, to get some benefit, is violation of copyright. But some conditions are there where we cannot term as violation. Say, for example, if there is a class, a teaching material where we are making the student understand what is violation of copyright, and we are referring a particular scene of Three Idiots, which was under the challenge, which was questioned before the court also, whether it is violation or not. So we are taking that particular creative of others only to bring the ideas, which is my own idea, which is my own expression, but to reach on the particular conclusion, we are referring the particular work, the particular part of the particular work, then that cannot be treated as violence. In the same way, in dramatic works, in literary works, same will apply. If we are not taking it in totality, we are taking it to reach in some other conclusions, not focusing on the particular work, concluding the particular work, then that cannot be treated as copyright violation. Therefore, only on certain conditions, even taking someone's work cannot be the violation of copyright or infringement of copyright. Now, what are the actions that one can take for the infringement of copyright? But before the actions, what we need to procure, what are the requirements for the actions of copyright infringement? These things are very important to understand what are the requirements or not. The very important thing is the proof of ownership of copyright. We know that one thing, that registration of copyright is not mandatory. Registration of copyright is optional. But we, being the student of copyright law, we prefer the registration because the registration cost only ₹500, and there is a form that we can fill up and we can send for the registration. But without registration, proof of ownership will become difficult thing. Sometimes it may happen, and we experience in lot of cases, we experience that the original author has written something, some ideas, expressed some ideas, but that idea was published, taking from the original creator, published by other person. When it was in challenge, the person has lost the case because he has not published the work. And in copyright, the very important term is, the formula of protection is, the copyright protection is available only in expression, not in idea. Therefore, the idea is not protected, only expression of the idea is protected. So without registration, the academician may face a problem in proving that the person is the owner. Therefore, registration may be advisable. Substantial similarity between the original work and the infringed copy. As just we have discussed, that taking a particular part of any work cannot be termed as copyright infringement, because our creation is something different, our conclusion is something different, but we may refer one's creation to prove my point or others' point. So in that case, that cannot be termed as infringement. Copying amounts to improper appropriation. Yes. This is another important conditions we have to remember, that when someone in appropriation of some works, in a person's works, and the particular, if we take the example of plagiarism, what our senior Dada has left on me, that percentage, the amount of copying permitted or not, allowed or not, that is also a part. But in copyright, that is not the part of copyright. In copyright, only two terms is there, whether it's copyright or not. Only one thing, it is copyright violation or it is not the copyright violations. Only two things is there. But what amount of violation is permitted, what amount of violation is not permitted, that is not the purview of copyright, that is the purview of plagiarism, so for academicians world is concerned. Therefore, what amount has been infringed, that is an important essential, because to reach on conclusion whether you have taken substantially, the second important thing, substantially to make your own, or you have referred partially to make your own, that is the most important thing here. Now, the today's world, we know that the creation of copyright is focusing on internet and web also. But how the copyright is affected, how the copyright is rated on web also. Basically, what we academicians, the student of any subjects who are involved in study and research can, what we see generally in practice, can use these things for their work. Overall design. One website is designed by someone and other person is taking the same designs from that website. Linking. Linking also very important part here. So for the infringement is concerned, we know sometimes that linking is free. Linking is free. But whether we are allowed to link, I am referring one important instance, one digital national digital library has been set up by the collaborative works of Delhi IIT and MHRD and IIT of Kharagpur. And Lord, there is a huge materials is available in the data bank. And if you go through, then it is allowed that any educational institutions, research institutions can link that website to their own website, to their own digital library, and anybody can get the access free of cost. But why it is written? Why it is allowed? Because it is restricted one. This act is restricted one. But generally what happened? What the website designers, even they have no idea about the copyright perspective of this linking. So they generally link one website with the other website, and when we click that, they enter. Entering in the website is not an issue, but entering in the particular information which required permission is the violation. If we link somewhere which is open to all, that is not at all violations. But if we give a link to the particular place where we required permission or authority to enter, then that is not allowed. Original text. If what happens generally, when someone copied the text of other websites or other web resources and get it pasted in their own work, that is also the question of infringement. Graphics, audio, video, other unique and original elements which we should not copy without taking permission. Now further, I'm coming to this, the social media here only. The same way, what we do generally, I think whenever we are getting any messages from other person, we generally transfer it, tag with others, share with others, but whether we are allowed to do that or not, that is a question. But so far, the spirit of copyright law is concerned, we are not allowed to copy, we are not allowed to share others' post if it is not permissible, if it is not allowed. If someone allowed me, someone tagged me to share, that is permissible. But taking one's post, and if the person is not allowed, I have got one question. I am eager to share this. When I was giving a lecture on in Calcutta Police on cyber law, so one question was very relevant. It's very interesting to share here on social media. Say if someone tagged me to share, I have shared that, and someone posted it, and I have shared that. So question is very relevant. Question was that, sir, it may happen in Facebook that if any person don't want you to share, their share option will not display under that particular post. It will not display. But whether it will display or not, that is only technical part. The creator, the owner of the particular picture may not be aware of that particular options where whether it can be put off or put on. So basically, we cannot take the defense that, you know, technologically it was available. That's why I shared this. We remember the case of Professor Ambikesh Mahapatra. What happened to him? He just shared that opinion, that particular caricature, which was posted by some other person. So law is very clear. Our cyber law is also very clear. Section 67 clearly says what are the cyber offenses and what are not the cyber offenses. So if we take the reference of this IT Act also, it is very clear to all of us that taking anyone's web content, taking anyone's information, social work, and sharing it without his information is not only the violation of copyright, but may attract the cyber offenses also. So we should be very, very careful in this age of social media in sharing anyone's post. Now, action against copyright infringement. We know that there are two kinds of actions available in IPRs. Basically, I am focusing on this civil actions, and I have also categorized some actions where these actions are separate actions called Anton Pillar Order, this Madheva injunction, Norwich Pharmacal Order. These are all the very specific actions. These are very specific actions, and these actions have a separate category. But since they are all civil in nature, I have kept this under civil action. So when someone's copyright is violated, infringed, and suffered loss due to infringement of copyright, one can move to civil action by filing the civil suit in the proper court of jurisdiction. So the first one, he can get interlocutory injunction so that the violation will not continue, so that the violation will stop on that very moment, injunction is granted. And if someone, due to the infringement of his right, if someone suffered any loss, substantial, it happens mainly, it happens in case of piracy. In case of piracy, it happens. And for that, the financial relief is also granted. And what would be the amount of financial relief? Basically, this depends on two conditions. One, amount of the financial gain that particular infringer has got. A second is the loss that person has suffered. Loss may be the market loss, the loss may be the financial, actual financial. Actual owner or creator of the copyright. Anton Penal order is the very interesting order, which is, this order was for the first time in India. It was issued but actually it is from British, where the court can issue an order that through this order one can issue order for seizure of anything. This is an administrative kind of order. From realize the person's whatever the infringing material he has, everything through administrative order only they can do this. Where in India, before this order, it was only available in criminal action. Mareva injunction also one kind of injunction where if the thing is in question, whether I am the owner or some other person is the owner, in Mareva case, it was decided by the court that whoever may be the owner, but stop further distribution of the particular right in question. Say, for example, someone has got some infringed copy and distributing the copy to the persons, to the retailers. So through this injunction, through this Mareva injunction, that can immediately be stopped. And Nordby's pharmacological order is the order where this is also administrative kind of order, which was also, these all three orders, actually these all orders are the order which was developed by the judiciary. Therefore, in this order also, one can get the power to stop, one can get power to recover whatever he has termed or claimed to be infringed or infringed product. And in criminal action, the first action is the season that was I discussed in civil also, search and seizure. Previously, it is actually order which was available in criminal action also. If someone wants to seize and search, then they need only order under criminal law. But after this Anton Penal order, we got that jurisdiction in administrative also, in judicial also. And if someone found to be the guilty of infringement of copyright, he may get the imprisonment for not less than 6 months and maybe up to 3 years, and fine which will be at least 50,000 and up to 2 lakhs. But remember, we have to remember this is the fine only for the offense, not for the loss. If someone, it may happen sometime people may think, okay, someone will commit the offense and pay 2 lakhs fine. No, this is a fine, and for the offense only, and for the loss, he has to pay what we discussed in civil action. Now, the exception. What are the exceptions? What we need to understand? We have already discussed about the fair use. The use which has no financial involvement, which is not in any way connected to the commercial exploitation. If we are using any copyrighted material, we are using any copyrighted sources, information, and that has not been used for any commercial benefit, then that is called fair use. That fair use may be for the research and progress, for the education, and second is for non-availability of the work in public domain. If anything, we suppose a college or a university know that a particular copyrighted work is very relevant for the research or development in particular subject. But those copyrighted works are not available in market. And they are able to get the Xerox copy or the pirated copy of that particular work. Then they can keep it in their public library with a particular record that this Xerox copy or the copy of a pirated copy has been kept in the library as this work is not available in public domain. So the basic thing for this particular offense called copyright infringement is determined only on the basis of the term called commercial exploitation. Okay, now beside this copyright, I think Professor Shaha has elaborately discussed about how to get the right, how to get the patent. I will discuss a very small part of patent, and thereafter I will finish my presentation. The patent, what we already discussed, what we already learned from earlier speaker, I want to focus only as my topic is IPR creation. So the academicians can create intellectual property through copyright or through patent. How they can create through patent? Now, patent is very important thing for the right subjects called science engineering. So if someone developed anything which has a commercial use, industrial use, then they need the protection. Again, like copy is an exclusive right which is granted to the inventor, the patentee, and the patentee can also use his patent for his own benefit. He can sell it, he can transfer it as copyright, like copyright. He can exploit his right in any manner. But how to get the patent? How to create the patent? The important thing is that if someone has created anything, if some academician has created anything which he believed to be a work which is unique, which is not obvious. Not obvious means any layman cannot understand the thing. That requires a specialized skill, the specialized knowledge that is possessed by that particular person who has invented. And the most important thing is that having industrial application, having industrial use. Until that has industrial use, the patent protection will not be a third very important thing as the formula, the development, the invention must have a industrial use, and that use means that particular invention must give us some financial benefit. So how to get it? After that invention, if academicians believe that we have these things, then what happened? We can send it, we can apply to the patent office. There's a patent office, and we have to apply it by filing. There's a form prescribed for filing the patent application. And after filing the applications, with the applications, they have to file the detailed specifications also. And they can file the patent application without specification also. If they think that specification I will not submit with the application, they may not submit it. Okay, so they can submit it, but after filing, the applicant has to submit an application with a request for examination. The formula, the development, the invention has to be examined. And that application of examination must be submitted by the applicant to the patent office within 48 months. Within 48 months. If they not submitted it, they will lose. Their application will be lapsed automatically. And after that examination, the publication will be made. Publication of what? The particular invention will be published in the official journal, inviting the public opinion. Inviting the public opinion that whether the work submitted by the applicant belongs to him or he has taken it from others. So that objections is to be invited from the public in general. And if they receive any objections or anything, then a report by the controller, the examiner, first report is to be submitted, and after submission a report by the examiner, the applicant has to submit the response. If any complaint, any objection received by the examiner from the public, then that has to be justified. That has to be, response has to be submitted by the applicant within 31 months to the patent office.
Professor Shah, Professor Mondal, I just want to interrupt a little bit. So please make it a little bit short because we are already off time. We have already overshoot our time for a large margin.
Okay, sir.
So I would just request you to make it a little bit short, sir. Please.
Can I get 5 minutes?
Okay.
Hello?
Okay, sir. Yes, sir. Yes, sir. Okay, sir.
Okay. So after, if they will not submit, the applicant will submit within 31 months their whatever from the date, priority date, then again it will be treated as abandoned and the application will be abandoned. So they will not proceed with the application. And if they submit the response against the report, thereafter, if all objections are received, concluded, the objections time, the publication's time is over, and if they found some objections, a hearing will be given to the applicant. A hearing will be given to the applicant, and the applicant has to satisfy the patent office about his work, denying or justifying all the objections received by the patent office. And if they get it satisfied, the patent certificate will be issued to the patentee, and the patentee can get the certificate and will become the owner of the particular invention. And thereafter, after first 3 years, they need to pay the fees for the registration from time to time revise, whatever. But after 3 years, that will, whatever the deposited by the applicant will be for the 3 years only. And after 3 years, every year, the patentee need to submit the annual renewal fees to the patent office. In this way, the academicians can create their right in terms of patent or in terms of copyright. In patent also, the right is exclusive, and he has the patentee has the right to use it, exploit it commercially. And if there will be any infringement in patent also, the patentee has all right to move to the court to get the infringer punished through criminal actions. With this, I'd like to conclude. Thank you very much. Once again, I would like to extend my thanks to the organizer, to the principal, to the convener who has given me the opportunity to speak on today, and to my senior Dada, Professor Jayanta Kumar Saha, for giving me the opportunity to be the part of this wonderful workshop. Thank you.
Thank you, Dr. Mondal. Thank you once again for your very informative and very detailed speech on IPR. We could really know the particular detailed information, I would like to say. Sir, we are already overshoot our time by a large margin. Sir, I just want to ask you a few questions from our question chat. One question is by Shubhrabakul Kormokar. He has asked, what are the fallacies of IPR? So can you please tell us in very short, what are the fallacies of IPR?
See,
IPR law,
fallacies
yes. Of IPR law.
Yeah, see, the basic thing is that IPR is a bundle of rights. So we cannot compare copyright, patent, trademark. So what about the fallacies of IPR laws? I must say, being a student of law, I must say that only thing is that the time in terms of patent, the time. In terms of copyright, the time. I being a student, find only one is the time, and a lot of examples I can share with you. We have lost a lot of things. In US, when you file one patent petition, you get the patent within 12 and 14 months. It was earlier, it was about 24 months. They have come down, they have make it 12 to 14 months, you'll get it. If everything is all right. Maximum is 24. And in India, maximum is unlimited, minimum is 5 to 6 years. So what happened? Our doctors are filing a petition for patent application for the grant of a patent of very important medicine which can be used in curing cancer cells. And we got patent after 8 years, and with the same formula, the US doctors filed the patent and they got the patent after the lapse of 3 years, and the date of application of patent in India, in US, was 2 years gap. But they have got, so what happened? They have got the world market and we have got the Indian market. Indian company got the Indian market, and American company, as they got the patent earlier, that's why they got the world market. So this is a fallacy. We have the law, but we are losing everything in terms of world economy. We are losing due to this. I think the government should think this. We know that we had a lot of obstructions. We know that we had a lot of crises, but still we can think of, the time has come when we have to think of the process to minimize the time span to get the better benefit.
Next question from Lakshmi Narayan Mahato. He has asked a few questions, very interesting questions, but I'm sorry, Lakshmi Narayan, I can't ask all of them. His question is whether the supervisor or guide of a research scholar is entitled to the content of the research thesis to be used as his share for his contributed part as his copyright?
No.
May I repeat the question?
Yeah, I understand. I understand. And my answer is in one word, it is no. See, a research guide is supposed to, the very term research guide and supervisor is to suppose the supervisor research the person, and these always, the work always goes to the researcher. That's why Mr. Mahato must be knowing that whenever any researcher is submitting the thesis, that the guide has to submit a certificate, guide has to give the certificate, the work has been done by the researcher itself. So it is a proof that the guide cannot claim that is my work. Even if the guide has contributed something, but they cannot claim as his own work if the work is done by the researcher.
Next question from Biprendu Chatterjee. He is asking that when a TV serial is broadcasted, the name of the characters are the same with the original novel, containing the same name as the serial, but the story differs. So can this be considered to be an infringement?
No, sir. See what happened, as we discussed, that a copyright owner has right of translation, dramatization, adaptation. These are all the right of copyright owner. So just I referred one case that Chetan Bhagat versus this, I'm not getting the name of the person, the producer of Three Idiots. There is a case. So Chetan Bhagat filed a case that he has not received the amount of compensation which he's supposed to get due to huge profit of the film. Isn't? Why? Because his idea was converted during the film. And the court ruled out, since you sold out your right on a certain amount of money, now you cannot claim you sold out the right. See, copyright owner has one very interesting right that cannot be transferred. That is called moral right. Right of paternity and right of integrity. Paternity, mane babar mamato je adhikar hoy, that right cannot be transferred. Even if a person is selling the right, even a person is transferring the right, but the moral right always remains with the author. But if the moral right is not transferred and you have got the money from the particular thing and you have transferred the right to modify the work also. So when a particular producer of a TV serial purchases the right, I have the experience, I'm telling you, there's a contract. And in contract, it is written that I am also selling my right to the producer in terms of modification, translation, everything. Therefore, whatever we are watching on television, change in facts, that includes the right transferred by the author to the producer, that is right to modify the work.
The next question from one Rishisha Dikar. He is asking that if a person has published his work in one journal and again published another similar paper in another journal, taking some points from the previous work, will it be an infringement of his own work?
No, suppose there is one work created by S&M. I have created one work and I have published the work with some publisher. See, two things there. If I have surrendered my copyright to the publisher, then after surrendering my copyright, if I am publishing that very article to other journal, I am violating copyright because I have surrendered my copyright, transferred my copyright to the publisher. But if I have kept my copyright with me only, then I can again publish it. There is no issue. See, it depends whether you have surrendered your copyright to the publisher. If yes, then it is copyright.